All right, staying with the Senzo Meyiwa murder trial, Kelly Khumalo's lawyer Magdalene Moonsamy's request to be back in the courtroom was unsuccessful today. Her request for a watching brief was denied. Let's speak to Moonsamy herself now just to get her reaction on the court's decision. Thank you very much for your time here, Ms. Moonsamy. How do you feel about the fact that the judge upheld his decision not to allow you on a watching brief for your client?
Thank you so much for having me. I think the first thing is that it's not about feeling. It's about the fact that there was consideration. If we go back to the court recordings earlier this year, one would then note that Judge Mamela said that I am temporarily recused. And secondly, that when the time arises, I will return to court. So it was not upheld in a manner that was written off. So to respond to that question, there is no concern in that regard.
So they mentioned a point 1.1 and a point 1.2 in your letter from today, or in your application, and they were saying that you have no right to what you're asking for there, making mention here and there of transcripts and some of the evidence, etc. Why did you want access to those?
Well, I think that it is common knowledge. This trial is being broadcast. Now, what we have is that there isn't always consistency in terms of coverage. So having access to the court recordings is something that is a basic right of any public person in this regard, because it is also broadcast. So there is nothing averse in terms of asking for access to the court recordings. Transcripts is just taking it a step further. To say that we would want to then be able to analyze what is it that has been said in terms of evidence that has been led. And the request for that, whether it is prejudice. If it is denied, it is prejudice, because the utterances that have emanated are quite clearly an aversion from the court process and what is justice that must be given in terms of both parties having the opportunity to be having access to the court recordings or the process. I will get into other issues, but in the instance, I think for me, it is us simply saying to the court, we want to follow the procedure in requesting the court recordings and access in respect of 375, because as you would know, 375 has been a huge contest. There has been an application made by Defense 45 in respect of the aspect of the 375 docket. It was in a dispute. The court then ruled that it would be looked into post de facto, the primary docket. So for us to be able to understand really what it is that 375 charges entail is just a procedural issue. It is our request that we're placing to the court. And if we are denied such request, then that will really disclose what then the intentions are and what are the rights that are being abrogated in respect of the process.
And just lastly, Magdalene, what's your response to Advocate Mshololo, defense for accused number 5, in her reasoning asking the judge not to allow you in on a watching brief? She said that, you basically have no reason to right now because the state or the prosecutor in this instance is there to protect the interests of your client because she would possibly be called as a state witness.
I think, let me alert you to the following. My role as a watching brief has been due to the fact that there has been numerous instances where client has been called in for interrogation, etc., been asked to come in for consultation, and later it has been that no, there's no need for consultation, client is not a state witness, client is not a suspect. So there has been inconsistencies that have been going around.
On the part of the state?
On the part, yes. So this is where the watching brief aspect comes in, simply because we needed to have clarity as to what is really the way forward in this matter. Now, the issue regarding the utterances, which are very sensationalized by a defense for accused number 5, referring the matter as prejudice to the accused. Let's ask the question, what about prejudice to the witness who has been affected in terms of charge count number 3, where she was directly, there was robbery and aggravating circumstances on count 3.
Yeah.
So that also prejudice, in my view. Now, when she goes on to speak about compromising the nation's patience, I want to ask the following question. Who is the voice of the nation in this regard? Is it not the court that must administer justice? So this really is a violation and a prejudice of rights of my client, of which should not be entertained in a court of law in terms of being a spokesperson of the nation. So I think that is really my response. Thank you very much.